Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. A lot of people want to know what they're supposed to do if they fear for the safety of their child during parenting time. Well, that's a very, very interesting question because the parenting time is a schedule. Presumably, it's a schedule set up by the court. So it's hard to understand how someone could have gone before the court, argued the schedule, came up with a schedule, and yet the issue of safety of the child hasn't already been resolved. But let's say it's not. Let's say you worked out the schedule without knowing that there is a genuine threat to the safety of the child. For example, you work out a schedule and there was never a problem before. You've been noticing, however, that when the mom comes to pick up the child, she seems to be intoxicated. Or maybe she's high or something like that. She's developed a habit where she is drug dependent. And now you're realizing that, wait a minute, this could present a hazard to the child if the child is in that environment being driven around by someone who's intoxicated, for example. This could present a safety issue. So what steps can you take if you find that that's the case? Well, number one, you ought to bring it to the attention of your attorney. And you ought to also bring it to the attention of the other side. You ought to tell your ex, look, I'm concerned about your driving the child around because the last couple times you've been here, I've detected the smell of intoxicants. What's going on? Do you need me to pick up instead? What's the deal? You're not drinking around the child, are you? You know, that kind of thing. You want to do it in a benign way, in a non-accusatory way, but you want it to be clear that there's a safety concern. If you cannot get any traction, if you cannot get any improvement as a result of bringing this to the attention of the other side and bringing it to the attention of the lawyer, who no doubt will mention it to the other lawyer, if you're not getting anywhere with that, then your lawyer's going to tell you, look, we're going to have to file a motion. We're going to have to file a motion. We're going to have to bring it to the court's attention that this is going on. And we're going to have to ask the court for some remedy. The remedy could be that the court denies parenting time, or suspends parenting time, or requires the person, for example, to take a breathalyzer or some sort of alcohol test before the parenting time goes on. And maybe after the parenting time is concluded, the court may take these remedies, but they'll never know whether this is appropriate unless you bring it to the attention of the court. So I would say the three steps are, number one, bring it to the attention of the other parent. Number two, bring it to your lawyer's attention, and if need be, bring it to the attention of the court in the way of filing of a motion. If you have any questions about this, reach out. We'll be glad to help you out.